Ready, start. It is further submitted that the aspects of pregnancy and abortion were duly proved in the case on the basis of the medical reports and abortion papers. It is further submitted that there was no enmity between the victim and the respondent numbers 1 and 2, and thus there was no motive to implicate the respondent numbers 1 and 2. It is further submitted that even if the High Court had found any procedural irregularity, it ought to have remanded the matter back for fresh adjudication instead of acquitting the respondent numbers 1 and 2. To buttress, it is submitted that the impugned decision completely disregarded the rights of the victim. Per contra, the respondents advanced submissions in support of the impugned decision. On their behalf, it is submitted that the investigation was carried out in a completely casual and negligent manner, and the same caused prejudice to the respondent numbers 1 and 2. The submissions draw attention to the aspects of age determination, absence of proof of pregnancy and abortion, lack of investigation qua the date, time, and place of the incidents, etc. It is further submitted that the charges framed by the trial court were defective and the entire trial was conducted on the basis of defective charges, thereby disentitling the respondent numbers 1 and 2 from a fair participation. It is further submitted that the trial court conducted a joint trial of the respondent numbers 1 and 2 in utter violation of section 223 CRPC and without fulfillment of the conditions contemplated thereunder. It is further submitted that even at the stage of section 313 CRPC, the incriminating evidence was not put properly to the respondent numbers 1 and 2, and consequently the respondent numbers 1 and 2 were prevented from explaining the evidence against them in a proper manner. Further, it is submitted that the version of the prosecution witnesses, especially that of the victim, was not consistent, and the trial court committed an error in placing reliance upon their testimonies. It is further submitted that the defense witnesses presented a valid defense and the same ought to have been considered. Both the parties have filed written submissions and compilation of judgments in support of their case. We have considered the same. We have carefully considered the contentions advanced by the parties, impugned judgment of the trial court, and the decisions relied upon by the parties. We may first consider the issue regarding inconsistencies and contradictions in the prosecution evidence, which would require some degree of examination of the evidence on record. At the outset, it needs to be noted that the High Court has outlined a few specific issues in the case, that is, victim's age, date, and time of the incident, proof of pregnancy and abortion, and delay in lodging the FIR. Before appreciation of evidence laid on these aspects, we may first traverse through the testimony of the victim examined before the trial court as PW2 in order to understand the precise allegations.